Yes.
We're unmuted.
That's what?
We're unmuted.
Oh, unmuted. Got it. All right. Testing podium mic. Good. Sounds good. Testing. Registered here, but I don't hear it in the. Doesn't matter. We're not using it. Testing. Can we not? Testing. All right. All right. Testing Justice 3. Justice 3. Testing Justice 4. Testing Justice 5. Justice 5. I'm going to turn you up a little bit. All right. That's touchy. Testing Justice 6. Yeah, it's Justice Lawrence. And testing Justice 7. Yeah, it's like the ones I'm adding are noticeable difference. I don't know if that's something we can do.
Well, yeah.
Good afternoon. Be seated. And the matter before the court is Lincoln 2556, Patricia Minerich versus Boothbay and Boothbay Harbor Community School District et al. We are being streamed on the web, both by video and by audio. I see counsel are present. I'm assuming you're ready to proceed. If you would introduce yourselves by saying your names for the record, together with the party you represent.
Kristen Collins for the appellants.
Good afternoon, David Cowan for the Appellate Community School District in Maine board members.
Thank you. And Attorney Collins, if you're ready to proceed, we'd be happy to hear your argument here this afternoon.
Thank you, Chief Justice. May it please the court, this case presents bigger issues related to the right of citizens petition, but the court's decision, and I think the crux of our argument today, comes down to the specific text and intent of Title 20A, Section 1504. That statute gives a narrow window of 7 days for 10% of the voters to, by petition, request a reconsideration of a school bond authorization. And the petitioners in this case were able to achieve those 347 signatures in 2 small towns over 7 days in the winter. They presented their petition, and it was summarily rejected by the school board of the CSD. Why was it rejected? I would submit that ideologically it was probably rejected because this school board was quite dug in on this particular school project, enough so that even though the voters had rejected it back at a November general election with high turnout, the board decided to put it back in front of the voters for another round several months later. And they did not want to see that vote reversed. Nominally, though, the board broke it down in their order to 2 things. On Article 1, they said that it requested an article that was different from the one that had been voted. And on Article 2, they said it is unrelated to the April 24th, 2024 referendum. So the order treated the articles separately. Unfortunately, when the Superior Court looked at this, it lumped the 2 together. And I do not think that was appropriate because there are 2 statutory provisions, one under Title 20A for school, one under Title 30A for municipal warrants that say that the articles are supposed to be broken down distinctly by subject matter. That's what was done here and what was intended here on this petition. When one article is challenged, we certainly don't throw out the whole ballot. So in this case, the board had no discretion, period, to reject a petition to reconsideration. And this was a petition for reconsideration in Article 1 because it specifically invoked Section 1504. And in the municipal context, we have case law and we have a statute that gives a right to reject a petition. But even in that case, petitioners can go to a notary public and still get that article put before the voters. In Title 20A, under this statute, there is no right of reasonable refusal. It is a mandate if a petition is given to you that invokes 1504. So what the board did here directly goes against the holding of this court in Friends of Congress Square Park, that grants of initiative and referendum powers should be liberally construed to facilitate the people's exercise of their sovereign power to legislate. And as in Friends, this court should order the holding of the election and remand this to the Superior Court to enter attorney fees.
Can I ask a procedural question? Has anything happened? Has the bond issued? Has it gone to the financing people? Has the project begun? Have the bonds been sold?
It's a wonderful question, and the answer to all of that is no.
So everything has been kind of put on hold?
Correct. I don't know if it's because of this litigation or for other circumstances.
You've indicated that under 1504 sub 1 that there really is no discretion, that the board must, in fact, initiate a new referendum to reconsider if the appropriate petition is filed, right?
Yes.
Even with that, though, doesn't the board have the right and indeed the duty to determine whether, in fact, what was presented is indeed a petition to reconsider, or whether it's something different or more?
I think the board needs to look at the substance of the article they need to look at whether it met the 10% threshold, and they need to look at whether it met the 7-day period. And in the text of Article 1, it clearly invoked Section 1504 and used the word reconsider.
But it was only one petition. It wasn't two separate petitions. And it went on to, in addition to Article 1, saying that it should be reconsidered. It had another article that said, and by the way, spend a much lesser amount.
Correct. And they were
And
intended to be.
But you agree, that doesn't fall in the category of a petition to reconsider by itself. Article 2 doesn't fall in that category.
If the voters had presented this as a petition for reconsideration and it had 2 articles under that, maybe that would be a little bit more ambiguous. They presented one petition. It was not titled that. Article 1 invoked Section 1504.
But what it says
Article 2 didn't.
in the preface on the petition is that the undersigned, to the Board of Trustees, the undersigned voters hereby petition the board to initiate a regional school unit referendum. I mean, and is there any power for the board to initiate a regional school unit referendum to consider Article 2?
Well, I think the language of saying a referendum rather than reconsideration is important in terms of the overall intent of the petition. I think that under number 1, it was clear that it's invoking 1504, and there was that right. Under Article 2, I think that's invoking a different statute, which is 20A, Section 1482A.
And would it be a referendum initiated by the board?
Correct. It would go to a school budget meeting, and to the extent that article was
Article
improperly.
2 explicitly references Article 1. It says if Article 1 on this ballot is validly approved, and then it goes on. So even the language of the article as referenced in the petition assumes that they would be on the same ballot. Why is that not the proper way to read this?
So I don't know that it does assume that, because if Article 1 passed, and if Article 2 invokes Section 1482A, that would require at a later period.
Well, Article 2 doesn't say it's invoking that statute.
No, and frankly, I think it would have been clearer if it did, but if the school board was looking at where the authority came for Section 2, if anything, that's where they would find it. But any voter signing this petition or voting at the polls, had it gone there, would have understood that we have to get rid of the prior authorization before we could consider something else, and that question 1 might pass, question 2 might fail. They were deliberately written that way.
If Article 1 was the entire content of the petition here, Article 2 is non-existent, is there any flaw with that? They say it doesn't, it says review and repeal, I think. Be reconsidered and repealed, and the town takes issue with that.
Yeah, and the order is without findings as to what they mean by that, and I think it's very confusing that you can't just have a question to reconsider on a ballot because it has to be a yes or no. And this was posed to verbatim repeat the original question and ask for a yes or a no. So there's no flaw in question 1.
Was Article or Question 2 timely submitted?
Question 2 is timely submitted. It just
Appellee's brief suggests that it was not timely, given it was submitted on May 1st, and that it had to be at least 15 days after the petition would have. The next meeting was not. It didn't line up with the next meeting, and does that have any significance here?
I think the board could have made findings in that regard. It did not. And if question 2 was flawed, and I think of these 2, there's more question about question 2, then the obvious answer is we have a mandate to put a reconsideration forward. There is no opportunity for these voters, other than outside of these 7 days, to prevent the issuance of this bond.
What if there was a third article which was completely unrelated to question 1? Something to do with the makeup of the board or something else with the school district, and that was tacked on here as well. Does that change?
I don't think it does. The articles state in distinct articles the business to be acted on. So you look at number 1, you look at number 2, you look at number 3 distinctly. They could have been submitted on 3 different petitions, but the effect would be the same.
Does the board have the ability to say we're only going to put up question 1 and not question 2 or 3 if there's a third?
So the municipal bar would appreciate some precedent on this, but we have no precedent about whether a petition should be severed. I think when you have a clear mandate under Section 1504, and you're going to shut out voters from being able to use their right to petition, you have to sever.
But what if it's not clear? I think that was the chief's question earlier. Does the board have any discretion at all to look at this and see, and ask itself and determine, does this conform with 1504?
I think they just need to look at those three things. Is it asking for reconsideration? Is it 7 days? Is it 10%? That is it's the extent of their authority, and I would not even call that discretion, because those are factual things they need to look at, which we're here.
But I guess so, in order to consider this a petition to reconsider and to put it on a referendum under 1504(1), doesn't the board have to sever 2 from 1? I mean, you can't, there's no authority for the board to put Article 2 under referendum in 60 days, is there?
I don't think so.
Okay,
But-
so they have to be severed, is what you're saying?
I think they either had to be severed in the sense of one not being acted on because the board thought that question 2 was problematic for whatever reason they wanted to cite, or in time and in method of voting, they had to be severed. So you'd put question 4.
Article 2, standing by itself, is not a petition to reconsider. I mean, you have to agree.
Oh, I completely agree with that. Yeah, that's
So-
seeking a budget authorization.
So it feels like, though, what you're saying is the board had the discretion, or indeed maybe even the duty, to sever an article that was presented to it by petition, that was part of a single petition signed by the citizens, and to essentially change what the petition says.
They would not have been changing what Article 1 said, and Article 1 was intended to be a distinct request for reconsideration. So they had a statutory duty to take that article and to act on it, and not rely on another question that asked for something different and try to reconstrue the whole petition as something different than what Article 1 specifically intended.
Can we unring this bell? I gather from what you've just said that the project hasn't actually started. The statute requires the reconsideration vote to have been initiated within 60 days, so we're well past that. Do we have the authority, if we agree with your argument, to send it back and tell the board now they have to initiate the petition well outside that 60-day window?
I think so. This action was brought within the 60-day window. That's really, I think, a deadline that's in there to protect the petitioners, to make sure that the board acts timely to put the article forward. And just to be clear, it's not to hold the election within 60 days, it's to initiate it. So if you now sent it back after it having been essentially put on pause for this litigation and ordered that the election is held, I think it would be a much more significant injustice to say we can't do anything now than it would be to say we're going to interpret the statute to allow us to do this under the circumstances.
Thank you, counsel.
Thank you.
Attorney Kalin?
Good afternoon, Chief Justice, Associate Justices, and may it please the court. I'd like to address some of the real-world consequences of the delay caused by this litigation, and it's a delay for litigation that the court has no subject matter jurisdiction to hear. The delay increases the costs of construction and borrowing. This is an outcome that is legislatively disfavored, and we know that because in another statute, in Title 20A, Section 15906, the state legislature says that in any suit challenging a school bond issue or seeking to enjoin the commencement, construction, or completion of any school construction project, the plaintiff must post a security, if they lose at the Superior Court, to cover the costs that happen as a result of the delay. And here, what we have is the effect of that, because a private lending institution will not lend on a bond without a clean bond opinion, which cannot issue when there's pending litigation. And the reason they will not lend on that is because of the precedent of this court that makes clear that if there is any infirmity in the approval, it goes back to the issuer. And so for those reasons, the existence of the legislation effectively prevents those institutions, because of their risk aversion, from allowing the bonds to be issued and the project to go forward. Here, they're not seeking that direct injunction, and so this statute doesn't apply, but the school district finds itself in that exact situation. Why do I say that the court doesn't have jurisdiction? Because there is no statutory right of review. The legislature sometimes creates statutory rights of review and has in Title 21A when the Secretary of State makes a number of decisions around referendum petitions. In those statutes, the timeframes are exceedingly short. The petitions have to be brought within 5 days. The court has to act within 20. Those statutes in Title 21A, for example, Section 303-A, Section 337, Section 356, and the last one, Section 905, which has very slightly longer provisions on the order of 10 days rather than 5. But as this court may be aware, that's the section that implements the court's own constitutional limitation to decide certain referenda issues within 100 days of the submission. So those timeframes are very, very short. That was the reason why the court held its first remote oral argument during COVID, because of that constitutional provision and the pendency of one of those cases. And so what do we have here?
So if what you're saying is correct, any regional school board unit could prevent one of these petitions from ever coming into play by entering into litigation.
That's not true. If the court looks at the case of Maine School Administrative District 37 versus Pineo, this was actually a school district suing the select board for exactly this. It's the mandamus action, which is statutorily available prior to the timeframes when they're supposed to act. That is no longer available once those have expired. And so if you look at that case, that was a case where the petition was filed, the court entered its order within 3 days, it went up on an, well, at that point it may actually have resolved and not come to this court. I'd have to go back and look at that. But the timeframes line up similarly with the timeframes you see when the legislature enacts them, and all of it is to compel the action that is supposed to happen immediately.
But by saying that, I mean, you're suggesting, and I think correctly, that there's no statutory authority for review under Rule 80B. And so then the question, as we said in Hurricane Island case, is it reviewable by some other means, i.e. one of the great writs? The suggestion is that it's reviewable by mandamus, but that is essentially for a non-discretionary function. If it's non-discretionary, aren't you giving it away at that point? I mean, i.e. the board had to schedule the referendum.
So there are two components to the mandamus. The first is whether it's non-discretionary, and I'll set that aside and get back to that, because as the questions indicated, this is far more complicated than a straight pulling the lever on a condition to reconsider. But the second is whether the mandamus writ, once issued, can actually affect relief. And that's why it's critical that it issue before the 60 days that they're supposed to call the election. That's what happened in the Pineo case, and that's the time period at which it was available to them. And that's not an inappropriate time period, because they had almost 30 days to do that from the time that the school board made its decision. And in the state statutes, in the 21A sections, they would have had 5 days or 10 days, depending.
I appreciate that argument, but I actually would like you to address the other part of my question,
Sure.
which is about the discretionary function.
And the other part is that if it were a clear petition to reconsider and that alone, then the school has the obligation to send that out to the voters. And we have every reason to believe they would have followed the law and done that. If for some reason they hadn't, then mandamus would have been available immediately. And the reason we know that it's not is the very questions that this court was asking to counsel for the other side. And that's trying to tease apart, what did the voters mean when they signed this petition? The reconsideration motion, since this is a legislative approval, that in the legislature is also very, very narrow. And we see that in Robert's rules. It has to happen at kind of their next meeting. It's all very quick. And this statutory provision for reconsideration was put into statute after the court ruled that it wasn't previously available.
If Article 1 and Article 2 were not on the same petition, if they were on separate petitions, you agree that that would be a valid petition, Article 1 standing alone?
So the problem with Article 1, the problem with...
Let me finish my
Oh, sorry.
question. That would be a valid petition, that the board would have no discretion as to whether to schedule the referendum.
Article 1, as written, as the board found, had another infirmity.
What?
This
I
would have been a
couldn't
closer question, and that's that it reverses the yes and no vote. So a yes on the first vote is to approve the bonds. A yes on the second vote is to
Why does the board
repeal
have the
bonds.
power to refuse on that basis?
So a reconsideration, the question would not be as worded on question 1. It would be the same question that they originally voted on. That's what a reconsideration is. It's a vote on the exact same motion. So it would have been a closer question.
This is effectively a request to repeal,
Yes.
not to reconsider.
Exactly. And so whether they could have reformed a request to repeal is, I think, a slightly closer question than whether they can reform a petition to vote on something that no one had ever gotten a chance to vote on, which is a less expensive alternative.
Well,
Because-
let's assume we've got a mootness problem and things like that. We have exceptions. It's only prudential. Your colleague has said, well, we'd really like to have some answers about whether, what the rules are that we've been talking about on the merits. So do you agree or disagree that it would be a good idea to find that this would be repeatedly, it will come up again, and so we shouldn't dismiss this on any mootness or prudential jurisdiction grounds?
So the court, I know, jealously guards the narrow exceptions to mootness. So I don't think this fits any of those. The capable of repetition but evading judicial review may be the closest, but the reason that's not there is exactly what I was speaking about before. The timeframes actually allow someone to get this issue decided quickly.
If it is done as a writ, a petition for a writ of mandamus.
Yes, but we would certainly, I think the bar would welcome clarity on the, well, the court's decisions are already clear that other than this narrow reconsideration, there isn't the ability to force a vote on these other questions. There's an unbroken line of cases, the Dunstan case, the Healds case, the Dobbs case. There's actually Justice Corton had a Superior Court decision in Field v. Harpswell where he repeats its dicta there because that was in a municipal context, but that school boards and towns can't be forced to send something for a revote on something that's already been decided by the voters. There is a very narrow exception to that, and that is this reconsideration. But that is, you have to put forward just, I want to vote on the same thing already voted on. And what we know, if you're a voter and you're being given a petition that asks if you want to vote on something that you haven't yet had a chance to vote on, and you sign that, it is much more likely that that is the article that is driving that for you.
So it should say something like, what you're saying is the petition should say something like, just do you want to reconsider the following article? Yes.
Pursuant to this statute, yes. That would be the clearest.
The school initiates the reconsideration. And if there's and as you say, to reconsider the original question. So you, meaning the school board unit, would have the prerogative of putting it out there as a referendum in the proper context. Do you want to reconsider the earlier approval of the budget in this amount?
Right. If you get a request for reconsideration that doesn't prescribe a specific form, this was a request to repeal, and it asked for a specific form. So if the voters are asked, will you present this question as written, then most of the case law around the country, and this court in the Avangard case refused to reform problematic language. And so it's not entirely clear, even under this court's precedent, whether that request to repeal would be enough to pull the lever for reconsideration. If the lever's just pulled for reconsideration, then yes, it is easy for the school board to basically take the exact same ballots, right? It's the same question that goes to the voters again, so yes means yes and no means no, instead of yes meaning no and no meaning yes.
But that's what the board could have done.
Well, the board couldn't do that here because the board had no way to know that the voters that signed this wanted that if they weren't going to get the thing they're not allowed to have, which is the ability to vote on this alternative.
So in your view, the petition, they're sort of inextricably linked. They can't be severed.
Absolutely. I mean, I think the language that you were pointing to earlier says that, but the very petition, if you're a voter being approached by someone in town, do you want to vote on a less expensive alternative? Yes. That is different than, do you want to re-vote on the exact thing you already had the opportunity to vote on? Which most people are less likely to say, well, I'll re-vote on the thing I was already outvoted on, if there's no alternative. They've lost that vote. The voters of the legislative body of the school district have already acted. And so that's why, as a matter of law, these bonds could be issued. They've been approved. It's just that as a matter of fact, because of the risk aversion of the private parties that would have to underwrite them and the pendency of the litigation.
The signatories to this petition here, they signed on. They didn't conditionally sign on. There were 2 articles there, so I think we can't start tinkering and you can't start tinkering as to who meant what when they did what. So the number of voters to satisfy the statutory threshold signed on to this, and I think that leaves you only with the argument that the end repeal and that the board made a discretionary call saying, whoa, okay, there's something else in here that really is surplusage, this is not a true reconsideration, and said, no, we're not going to do this, and that triggered the rest of the stuff, and the 60 days went by, but it all goes back to the board saying, no, we're not going to do this because we don't think that this satisfies the requirements of the statute.
May I answer? It was.
It's still yellow.
Okay, sorry.
Yeah.
So I think that might be true if you had only a request for reconsideration. But as I've tried to articulate, the thing that the voters were presented with was, do you want to vote on a less expensive alternative? And the board doesn't have the ability to say, well, if they had actually been asked, just do you want to reconsider, would they have also signed the petition? Can we reform that to say that only a revised version of Article 1, where yes means yes and no means no, was all that they wanted? And we'll go ahead and do that. And for the very reasons you were saying, the board doesn't have that discretion because they can't invent the motivation of the voter. They are stuck with the words that were presented to them on the petition.
Thank you, counsel.
So I take issue with the fact that counsel is arguing that this has delayed the process of issuing the bonds. The way to have gotten a definitive answer on this would have been to put the question before the voters. We would not have had to litigate this.
By the way, do you agree that it really isn't an 80B, that it has to be a mandamus?
It's an 80B that sounds in mandamus, yes. And if this had been litigated with a conclusion, then we would have an answer.
We have different rules. 80Bs and mandamuses. 80Bs take care of some mandamuses, but not all mandamuses, because we still have a statute. And the mandamus statute said you could have come tickety up right to the law court, and you could have expedited this. You didn't do anything to expedite this, and as a practical matter, you knew this was going to sit there forever, and you didn't take any steps to expedite anything, did you?
We actually did, in a procedural order, agree to an expedited process.
Expedited, faster than the usual.
Yeah, faster than the usual would have been probably a TRO in this case. The reason we did not do that is because we were being told that the school board was not going to issue. They couldn't issue because there was still litigation pending. So there was not that sense of urgency, because what we needed to get to was a final resolution of the case in order for them to be able to issue the bond, rather than an interim order like a TRO. So that was not done because we frankly did not have to, and it's an expensive way to litigate a case.
I guess you lost me on this. What does the TRO have to do with?
Oh, in terms of a way of expediting a resolution of the case.
I think what Justice Connors was referring to is the statute on mandamus gives you the right to expedite it.
Yeah, I mean, we saw it, and we were not directed otherwise by the court or in the procedural order that it was a Rule 80B appeal because it was dealing with a quasi-municipal school board action, and that's where it came in.
The board says, it's just simply said, we demand that the school unit board within 60 days initiate a new referendum to reconsider the vote of the previous one. If it simply said that you would be in, but because there's more added to it, more nuanced aspects to it, that is the tipping point, or I should say tripping point.
The statute has no procedure that has to be followed, no content that has to be followed. I think that these petitioners could have said, we're requesting reconsideration, and signed their names below, and that would have been enough. And it would have left the school board with the requirement to write whatever language was going to go on that article. It's not what they did, and what they did, though, still has the same intent and effect. It was clear. It would work a reconsideration of the vote. And if that petitioned article had passed, we would all know that it had gotten rid of the prior authorization. Thank you.
Thank you, counsel. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. And with that, we are in recess on this matter.
All rise.
seated. The matter before the court is Cumberland 25-109 Shark Tank Strategies versus the Town of Scarborough. We are being streamed live on the web with both audio and video. And I see counsel are present. I'm assuming you're ready to proceed. If you would introduce yourselves by saying your names for the record, please, starting with the appellant.
My name is Gordon Singh, representing the appellants.
Grady Burns for Pelly Town.
Thank you. Sorry, maybe I should have had that water. I'm okay. Yeah, I'm all right. I think I am. Thank you. Yes, then, counsel, if you're ready to proceed, we'd be happy to hear your argument, and I'll try not to cough.
Thank you very much. Good afternoon. May it please the court. Today, the court's being asked to determine whether the appellant's applications to the Scarborough Town Council were pending at the time a zoning amendment became effective, such that those applications would not be affected by that zoning amendment under 1 MRS Section 302. Now, the court has articulated a test to determine when an application is pending. In Littlefield versus the Town of Lyman, the court said that an application is pending when the municipality takes the threshold step of acting on the substance of the proposal, and then it enumerated 3 instances in which that would be the case. One, when the town accepts the application for the purpose of evaluating the substance of the proposal. Now, it doesn't say evaluating the substance of the proposal. It says something before that, accepting the application for the purpose of conducting that evaluation. Second, when the town manifests that the application was adequate to engage in the review process, to begin the review process. Again, this is contemplating something that happens before the review process, merely manifesting that the application is adequate. Not that it's complete, but rather it's adequate. And the third, if the town fails to advise the applicant of any restrictions on acceptance of the application. Now, in the undisputed facts of this case, on September 4, 2024, prior to the zoning amendment becoming effective, the council heard, the town council, Scarborough Town Council, heard public comment on and discussed the applications. The council advised the appellants that the applications would not be affected by the zoning amendment, and most importantly, the council voted to approve the first reading, to schedule a public hearing, and to schedule a second reading, thereby manifesting that it found the applications adequate to begin review. And it was, therefore, it was on these undisputed facts, it was legal error for the town council to determine that the applications were not pending. And part of the reason that they made that legal error was they applied the wrong test. In the denial document that the Scarborough Town Council produced, it did not address whether any substantive action had been taken. It simply said that the applications were not complete at the time that the zoning amendment took effect. That is not the test that the court has articulated in Cardinale, in Littlefield, and in Maine Isle. The court has expressly disavowed whether completeness has anything to do with the determination whether the applications are pending. The town's 2 cases that it rely on are factually inapposite. In in Walsh versus the Town of Orono, the planning board did not even have any review. There was no review of an application prior to a zoning amendment becoming effective, such that that application was not pending.
Well, you said that completeness has nothing to do with this. That's not exactly correct. I mean, a town can always choose to start a substantive review before the application is completed. And what we're trying to figure out here is whether, as a matter of fact, that's what they did. But here, their ordinance was very clear about first you find it's complete, and then you start doing the substantive review. So we could read this decision as saying, you know what, you didn't even get past step 1, and it's implicit that they didn't get step 2.
I have to disagree with you on what the ordinance says. It doesn't say you find completeness and then you engage in substantive review. There are certain things that require completeness, such as notification of abutters and scheduling a public hearing in the ordinance. However, the ordinance does not preclude the town council from engaging in substantive review prior to completeness.
But isn't there another problem? I mean, you've relied pretty heavily on language in Littlefield about the matter being pending if a municipality accepts the plan for purpose of evaluating the substance of the proposal or manifests that the plan is adequate to begin the review process. That was decided in, I think, 1982. And then the statute was amended in 1987 to add additional language. Doesn't the language that was added defining what pending means, in other words, that the reviewing authority has conducted at least one substantive review of the application and not before, and that a substantive review shall consist of the review of that application to determine whether it complies with the review criteria and other applicable requirements of law. So that language was added to 302 after Littlefield. Is that portion that you're relying upon in Littlefield actually still good law, given the amendment of the statute, Section 302 in 1987?
I believe it is, because I think that the amendment to Section 302 occurred while Littlefield was pending, and Littlefield addressed that, and it said that it acknowledged this additional language, and it may be Maine Isle, I may be confusing Maine Isle with Littlefield, but they were decided within a year of each other. And they said that that new language in Section 302 was consistent with how the law court had applied the old Section 302. So it did not, it expressly incorporated its prior decisions as remaining valid under that new language.
Well, Littlefield was 5 years before that amendment, so.
Okay, so I have that, that's not the right case, but the law court has said, and it could be Maine Isle or it could be Duplessis, yeah. But there's express language that states that that law is still good.
But the language of the statute seems pretty clear, doesn't it? It says, when the reviewing authority has conducted at least one substantive review.
So I agree with you, it's clear, but if you look at the facts that the law court has held constitute pending applications after that amendment.
So we were maybe wrong?
The court has interpreted Section 302.
It's happened before.
I'm not going to opine on that, but
It will continue to happen.
The court has interpreted Section 302 broadly, where in multiple cases there has not been actual substantive review. Let's, for example, a vote on a permitting criterion, and yet the applications were deemed pending on the facts before the court.
Would you agree? I mean, if we go to the actual language of the statute, the reviewing authority has conducted at least one substantive review of the application consisting of a review to determine whether it complies with the review criteria and other applicable requirements of law. Did that happen? If you just use that language, forget what we said in Littlefield, waste disposal, et cetera, what did this town council conduct such a review?
They did not vote on they didn't
vote on anything, did they?
Well, they did vote. They took a vote 6-1 to approve the first reading. Now, it's a little confusing because we're talking about a town council that's used to legislative language acting in a adjudicative capacity like a planning board would, so they're using different language, but they did vote 6-1 to approve the first reading.
But is that a substantive review? They were setting it up for a public hearing, at which time they would give notice to the abutters so that they'd be able to come in, and then the approval couldn't take, final approval couldn't take place at that first
I agree,
session,
I agree, but that is consistent with municipal practice where boards will conduct a review over multiple meetings before making a completeness determination, before holding a public hearing.
Well, let me ask you this. Could they have taken a vote on it at that September 4th?
I don't think so, no.
No,
under
because the abutters
council's
hadn't been
rules.
notified the application, in fact, wasn't complete.
Among other reasons,
Yes.
yeah. But
So what was the substantive review from your perspective then?
well,
at
there
that
were
first
discussions of they took public comment, the town council took public comment, and there was discussion of aspects like public safety, odor that have to do with the
It was
substantive.
discussed. There's
There
no
was-
question that they discussed things
Yes,
like
they
that.
discussed. So substantive review doesn't mean substantive action. It means was there any review, discussion, et cetera, and under the language of the statute that did take place.
Well, the ordinance says that you shouldn't have a public hearing until after receipt of completed application,
It does say that.
and which kind of tends to, when you read this ordinance, it kind of suggests that there is a logical progression, and the progression has not yet come to a substantive review until you have completion and a public hearing.
I agree with you, and as I just said, substantive review can occur prior to a public hearing, and the language of the ordinance does not preclude substantive review until a public hearing has been submitted or until abutter notices have been made.
But what you're saying is, as a factual matter, made substantive review happen in this instance was a kind of a brief cursory reference? I mean, what exactly was the substantive review that you think triggered pendingness, if that's a word?
Did you say pendingness?
Pendingness.
The pendingness occurred when there was, so I agree with you. It's not a situation where there was a vote on a substantive permitting
Let
criteria.
me ask this, was advising the petitioner or the applicant that they would not be subject to the amendment? Was that any kind
That
of
is-
substantive comment?
That is a factor that the court has looked at in determining whether or not an application was pending. In fact, in Cardinale, that set of facts where the town had advised the applicant that the zoning amendment wouldn't apply was one of the facts the court looked at to determine that the application was pending. And that's codified or incorporated into that Littlefield test where it says, look, if the board starts acting on something and they don't tell the applicant, hey, we're just acting informally here, we're not actually doing any substantive review, that will render an application pending, or it could. And in this case, the exact opposite occurred. The town council affirmatively stated, the chair of the town council, a town council member, a town councilor, and the town staff all stated at that September 4 meeting that the zoning amendment would not apply to these applications.
But you're not arguing.
And then later, they backtracked on that.
You're not arguing estoppel or reliance, or that's not a part of your claim, is it?
No, but no, I'm not arguing that. There was no detrimental reliance based on what was said at the September 4 meeting. It's just a factor that the court has looked at before.
Thank you, Counsel.
Thank you very much.
Attorney Burns, we'd be happy to hear your argument.
Thank you, Madam Chief Justice, and may it please the court. Section 302 and the case law interpreting that section are clear. Absent express language, an application is subject to the ordinances in effect when the application becomes pending, and the application becomes pending when substantive review of the application occurs. Per the statute, a substantive review only occurs when a board reviews an application to determine whether it complies with applicable review criteria and other applicable requirements of law. Such a review did not happen in this case until after the town's ordinance amendment imposing 1,000-foot residential setback for cannabis businesses became effective, and therefore the town council correctly denied petitioners' applications for cannabis business licenses on the basis that the applications would violate that setback. Fundamentally, this case turns on factual questions of what the town council did and did not do at its meeting on September 4th, 2024. As noted in the town's briefing, the meeting that transpired on September 4th was an informal, quote, first reading of the applications, something that precedes the start of the formal review process established in the town's ordinances, and which was adopted by practice over years to increase public awareness of cannabis applications prior to the commencement of formal review. At the conclusion of the first reading, the council, by practice, votes to advance an application to a second reading, which is in fact the beginning of the formal process established in the town's own ordinances. It is at this second reading where the town council's completeness determination, public hearing, and review on the merits occur. At the September 4th meeting, the town council heard public comment concerned almost entirely with questions related to the first reading process itself and whether the first reading conferred pending status on this application, the very legal questions that we're dealing with today. Following that public comment period, the town council in turn focused on these questions, ultimately moving the two applications forward without further discussion.
Well, what are we supposed to do about the fact that the decision only seems to be based on completeness, and that's not the right legal test?
So the decision here notes that the application is incomplete, but the fundamental, I think the operative aspect of the decision is a determination that the setback requirement applies to this ordinance, to these applications.
Is that one of the applicable review criterion, the 1,000-foot setback?
It was as of the effective date of the enactment of that ordinance.
And
yes.
didn't the board weigh in on that criterion on September 4th by telling the applicant it wasn't going to apply to them?
So at the time of that meeting, that ordinance was in fact not effective.
Understood. It was prospective.
Sure.
And the board said, don't worry about it, it's not going to apply to you.
So I would argue that the discussion of whether that provision was effective as to these applications is different than dealing with the substance of whether that setback would be met.
Is that because there's a difference between individuals, whether it be members of the board or the town manager or, code enforcement officers, et cetera, expressing their opinions during a hearing is different than the board or the town council as a group taking action?
I think that's an important component to this case.
We've got cases where we've said that, the fact that, various, like when it comes to findings, the fact that they may have said all these things doesn't make it the findings of the body.
Absolutely. And I think where this was in the process and the discussions that occurred, I think there are situations where when the board as a board actually undertakes an action to advance an application into the discussion of the substantive merits of the application, that action by the board as board might have an impact on the analysis. But the individual discussion of board members certainly is not an action of the board.
If the town council had actually voted as a body on September 4th to say that the application was complete and can move to the next stage, would that be substantive action?
So if the board had explicitly or even implicitly determined that the application was complete at that time, I think you would have a question under Littlefield as to whether that completeness determination constitutes an acceptance of the application for the purposes of substantive review.
Which comes back to my question about, is Littlefield still good, given that the statute was amended 5 years later?
Well, as the court well knows, the first step to any statutory interpretation is to look at the plain language of the statute itself.
I mean, what we usually think about on substantive review by a municipal body is when they start going through the review criteria. So it is a little opaque when the statute says, has conducted at least one substantive review. Let's say there's 10 criteria. If they start talking about criteria number 1, but they don't vote until on any of the criteria until 3 meetings later, is it pending? When they start talking about it, do they have to vote on it? When does the language of the statute get triggered?
So I think that it's possible that the board's undertaking of, so if the board begins the process of looking at the substantive requirements for approval and then goes through and undertakes that systematic review of whether the application can be approved under the town's ordinances, it's possible under the language of the statute that could be construed as substantive review. But I think here we didn't even come close to reaching that threshold. Really, the discussion here was so preliminary that the board didn't even delve into the merits of this application.
In fact, it would have been inappropriate to do so, given that people had not been appropriately
It would have
notified.
violated the town's ordinances, certainly. And while this first reading process is not contemplated in the town's ordinances, what it was really intended for, based on the discussion that happened at that council meeting on September 4th, one thing that staff and council members each discussed was the idea that this two-step process was intended to increase opportunities for members of the public to become aware of cannabis license applications, and to essentially increase the opportunity for notice and word of mouth to alert the public of these sometimes sensitive.
So do they only do that in cannabis applications, this first reading, second reading?
So I am not aware of the board undertaking this type of review for other.
Well, most things
types.
probably don't go to the town council, they go to other.
As appellant's counsel noted, the town council generally is a legislative body. Right. They're used to handling ordinance and legislative actions that do kind of follow this choreography of, well, we'll have first reading, then second reading. But as the staff and council members noted at that meeting, there is a fair amount of consternation about what this process is, where it fits into the town's ordinances, and ultimately, as staff and board and members at that meeting said, ultimately the vote here is superfluous. The board could have tabled this application until the date of the public hearing, and it would have the same substantive effect as moving it from first reading to second. The result would have been exactly the same. They would have taken up the formal application at that next meeting date and begun that process of determining whether or not the application is complete, determining whether or not abutters received proper notice, undertaking the public hearing, and then reviewing the merits of the application. All of those things came later. They came after this September 4th meeting and after the effective date of the ordinance amendment.
There don't appear to be additional questions.
Thank you.
I'm not sure if that's an advantage or disadvantage of going at the end of the day. Attorney Smith.
Thank you. To circle back to that question about the amendment of Section 302, the language I was referring to is actually in Waste Disposal, Inc., which is from
I suggested it might have been.
1989, and it says the statutory language, it quotes that substantive review definition in the amended statute, and then says the statutory language of the current version of 1 MRSA Section 302 is consistent with our interpretation of the prior version of the statute, and then it cites Maine Isle and Littlefield. And so I would argue that those holdings are still valid.
Do you think there would be a due process problem to start a substantive review without notifying the abutters?
No, I don't. I think that individual mailed notice to abutters occurs for certain events in permitting proceedings. Often it will be a public hearing, and that notice of a planning board a meeting at which any application might be discussed does not require individual mailed notice. The notice can be sufficient that it's published or posted with a planning board agenda with ample time to give people in the town notice. And the court has held, even in cases where that might be 1 day or 2 days or 3 days before, that's ample notice. And that there is no statutory or common law requirement for individual mailed notice anytime an application is
There was
considered.
an earlier reference to the issue of whether there was substantive action taken at the September 4th meeting as a question of fact. If it's a question of fact, who determines it? Is it the board? I mean, we don't, there was no fact-finding on the part of the Superior Court.
That's correct. I would say, I don't think there's any dispute about what the facts. It's the interpretation of those facts that's in dispute.
So who determines whether the past meeting was substantive?
So the court has said that it will defer to a municipality's interpretation of its past conduct in the context of Section 302. But
And the
here,
board basically took the position that their past conduct at the September 4th meeting was not a substantive.
the town council has never taken that position.
Council, I meant, but.
Well, the town council, I mean, has never taken that position. The town attorneys have taken that position in litigation subsequently, but the denial document did not say the reason that this application was not pending was because we had not engaged in substantive review.
You didn't meet the setback, which is implicitly saying we're applying the revised amended ordinance.
Right, by applying the wrong legal test, because the only thing that the town council denial said was that the application was not
wasn't
complete.
Thank you.
Thank you.
All right, as is our usual practice, we'll be taking the matter under advisement, issuing a written decision in due course. And with that, I believe we are in recess, actually, for the day and for this week.
All right. All persons having anything further before the Honorable Justices of the Supreme Judicial Court, sitting in the law court, they hence depart and give their attendance here at the call of the Chief Justice as this court now stands adjourned. God save the state of Maine.